be each about 3 minutes for opening, and the approximately same amount of time for closing. We're going to have a coin flip to see who goes first. We're going to go official here. And whoever gets to go first probably will get to go last, so we'll flip the order at the end as well. Does that sound all right? So Justice Sanders, since you are the sitting justice, you get a call heads or tails.
Tails.
Where'd it go?
He lost it.
It's his. Charlie wins.
So we had a little debate on Wednesday night, the same scenario.
One would have thought the odds would be with you that this time it would be tails, but I guess it's 50-50 every time.
And then after the openings, we'll open it up for questions as well. And we're going to try to limit it so that the questions are equal. In other words, if Charlie gets a question, the next question should be for Justice Sanders. So that's how we're going to try to do it, just to keep it fair for everybody.
Who's keeping count?
I guess I am. All right. And we are being videotaped, so if you do speak, try to speak up so that we can pick you up.
And we're going to put it on the WSAJ website for members to see. Okay.
All right, go ahead.
Good afternoon. First of all, I'd like to thank the association and the leadership for making this opportunity available to all of us. Both Justice Sanders and I are folks who are, I would say, give a fair shake to plaintiffs on every case. And so I don't think that's probably the greatest distinction between us. I've been a member of this organization for many years. I've been an Eagle since the time the Eagle program was first developed, with only one interruption when I was on the Court of Appeals. I've represented many folks in this room. I was kind of counting up this afternoon or this morning. I've represented, handled cases on behalf of 18 of the former presidents of this organization and future president as well. We had occasion to check the record, and we were looking for statistics on how often a verdict, a jury verdict, judgment based on a jury verdict is reversed if it's more than $1 million. And that's kind of a hard search to do on appeal because there's no category for that. So we were able to come up with about 18 cases in the last 25 or 30 years. I'm sure that's under-inclusive. But what was interesting to me about that was that I had actually represented the plaintiff in 10 of those 18 cases. So I come to this organization as a member and a longtime member, and one who has represented many injured folks in the past. And just to give you an idea of some of those cases, I represented the plaintiff in the Mahler case, the Washburn case, the Bunch case, and really many other cases as well. I think where the difference comes in between us is really a matter of experience and a matter of some of the things we look for in a judge. Experience-wise, I've been a judge on the Court of Appeals. I have been a pro tem Superior Court judge in King County and in Jefferson County, pro temming probably 18 or 20 cases in those two counties. Multi-day cases, anywhere from 2 days to 2 weeks in duration. I've been on the disciplinary board of the state bar. I've chaired that board. I've been a hearing officer as part of that procedure. I've been on the rules committee. I've done a lot of rules work. I just spent several hours yesterday on a conference call with a task force that's revising the rules that govern lawyer discipline. So I've had experience in all of the areas where the court works. Trials, where I've tried cases as a lawyer and as a judge. Appeals, where I've handled cases as a lawyer and a judge. The Supreme Court, where I've argued many cases. The rules process and the disciplinary process. The things I suggest that people look at in this election and in every judicial election are what I call the 3 I's. Integrity, impartiality, and independence. And as we think about that, I went to the mission statement of this organization and some of the goals of this organization, which are in the annual directory. And the mission of this organization is to protect and promote a fair justice system and the right to trial by jury for injured persons, even in actions against the most powerful interests. And I think that's something we can look at here. One of the goals of this organization is to defend the honor of the legal profession and promote the highest standards of ethical conduct and integrity. And I think I would bring that to this position, and I hope to talk a little more specifically about that as we go through this discussion this afternoon, and we look forward to your questions. Thank you.
Justice Sanders.
Well, for 26 years before being elected to the court, I was an active member of the trial lawyers. I remember one of my best experiences was down in Shalashan. I grossed 130 on the golf course, but got closest to the pin on one hole and got a weekend at Port Ludlow. So, I was an active trial lawyer. I represented all kinds of clients. I did a lot of civil liberties work. Since I've been elected to the Supreme Court, I've sat on about 2,000 cases, written over 570 opinions. I think that's more than any of my colleagues. Certainly I have the record number of dissents on the Supreme Court during that period of time. In my spare time, I was an adjunct professor at the UW Law School teaching appellate advocacy, written law review articles. If you go to my professional website, justicesanders.com, every one of my opinions is summarized, and most of my writings and speeches are right there too. So during this the last 15 years, I've taken the provision of our state constitution seriously that says that governments are, the purpose of governments are established to protect and maintain individual rights, Article 1, Section 1, and I've taken that to heart. I think that there's no one on the state Supreme Court that's a stronger defender of our civil liberties than I am. There's no one on the state Supreme Court who's stronger in defense of the rights of the accused. And like Charlie acknowledged, I have an outstanding record, I think, with regard to issues that are of particular interest to trial lawyers around the state. In fact, there's one little leaflet here, why trial lawyers are crazy if they don't support Justice Sanders, which is a two-sided flyer which goes through many, many different cases that I've either written a majority opinion on or dissented or signed on to that I think prove the point by looking at my public record. And some of these cases are not popular cases, but I took the hard road and did what I thought was right at the time. I remember shortly after I got on the court, Len Schrader wrote an article for the Trial News talking about the 3 strikes you're out case, where that was an 8-to-1 decision. I was the one guy, 27-year-old black man, was caught after he stole $300 from an espresso stand, armed with a finger in his pocket. He was sent up for life without possibility of parole. I thought that was a little much. I would have held the statute unconstitutionally cruel punishment. This was a non-plus for my campaign co-chair, Ken Eichenberry, who next time around co-chaired the campaign against me. And John Carlson didn't like it much either. But I told my daughter at home, she said, Daddy, you spent all this money and all this time getting elected to the Supreme Court. Now they're going to kick you out of there. I said, well, you know, the first face I look at in the morning is my own, and I've got to be able to look myself in the face, and no one goes to prison or stays there so that I can get reelected. And that's still my attitude. It was an interesting survey performed by the Evergreen Freedom Foundation. They have the Supreme Court blog about what justice agrees with what justice the most. One that agrees with me the most is Tom Chambers. Second most is Deborah Stevens. One that agrees with me least is Jim Johnson. So I think my record on the Supreme Court is clear. I'm proud of it. During the course of this campaign, it's not been a happy campaign for me. Mr. Wiggins has taken an extremely negative approach and faulted me for my record on criminal justice cases and other aspects. And sometimes I think he just makes it up. Let me give you an example. 15 seconds. He says in the Yakima Herald, Sanders also voted 91% of the time for lesser sanctions in lawyer discipline cases over which the Supreme Court has final say. In other words, Wiggins said Sanders' reputation as a libertarian maverick mass a liberal slap on the wrist philosophy.